Are the LDS Church's lawyers really fighting John Dehlin, Mormon stories, or Indigenous voices? Anini nanawe mag and ogima sangab mitiga ogichi da a jojepa nisha nindigo ojibwe mong. Adik nindu demabya yala nindunjaba me o omenekwa. Today I want to talk about something bigger than the lawsuit between the LDS Church and John Dehlin. Because after reviewing the court filings, I believe there's a question that deserves attention. If the church says this is only about trademarks and branding, then why oppose Indigenous participation that asks the court to protect historical, religious, and referential use of the terms Mormon and Book of Mormon? They come from the word Maamin. It's Anglicized. I come from the Midewiwin tradition, one of the oldest continually practiced spiritual traditions on this continent. I am a Midewiwin, or high priest. Our motion to intervene wasn't asking the court to decide theology. It wasn't asking the court to decide whether anyone's beliefs are true or false. It was narrowly focused on a legal question. Can historically and religiously significant terms be treated as exclusive trademarks in ways that affect broader religious, historical, and cultural discourse? Yet the church's response argues that we have no legally protectable interest and suggests these concerns are irrelevant to the case. Here's what I find troubling. The LDS Church publicly teaches that the Book of Mormon contains a history of ancient peoples in the Americas and was compiled by a historical figure named Mormon. This is the Anglicized term. At the same time, its trademark claim depends on asserting exclusive rights and names built around those same terms. You can't have it both ways. If these terms refer to history, religion, or people that existed before the church itself, then they are more than corporate brands. And they are repugnant to the Lanham Act, which is the corporate trademark law. The law prohibits the use of indigenous history or persons in trademark lawsuits. Perhaps we didn't speak before, but we're speaking now. And if they are more than corporate brands, then indigenous people and other religious communities have a legitimate interest when courts are asked to expand control over those terms. What's especially ironic is that our filing never sought ownership of Mormon or Book of Mormon. In fact, it argued the opposite, that no one should be able to use trademark law to monopolize historical or religious discussion. So the question becomes, if this lawsuit is truly about John Dehlin's branding, why fight so hard against a limited intervention that specifically excludes theological disputes and focuses on constitutional and trademark limits? From our perspective, this stops looking like a fight against John Dehlin alone. Starts looking like a fight against anyone who can challenge the idea that the terms Mormon and Book of Mormon belong exclusively to one institution. I guess when you have $300 billion in the bank, you think you can do anything. The Midewiwin existed long before this lawsuit, long before modern trademark. Midewiwin means those of the good heart, but it has a more ancient meaning. Mide, or Mino-Ode, or the good heart, is the name in our creation story that the first father called himself. He was called to name all things. The Creator told him, well, I made you too. We're trying to walk that path of that heart of the first father. We existed long before any corporation claimed ownership over language tied to history, identity, and faith. Whatever happens in court, this conversation matters. Because history is not a trademark. Faith is not a trademark. And indigenous voices should not be excluded from discussions that may affect how history and religion are spoken about in the public square. I'd like to encourage you to visit thebranchofpeace.org, where we have provided those filings, the initial filing, our response, their response to our response, and our response to their response. I want you to hear me closely. The first presidency of the Church of Jesus Christ of Latter-day Saints has taken the position through their lawyers to challenge the indigenous faith of the Midewiwin, who has stepped forward and said that Mormon and Book of Mormon are historical. Their response, their fight is, it's not and you can't prove it, while also saying at the end, but that they believe it is. This is therefore repugnant to the Lanham Act, which is the trademark corporate law. I want to thank you for watching this, and if you found this video valuable, please like, subscribe, and share your thoughts in the comments. We're almost to 50,000 subscribers. We're rising. Chi Miigwech, until we speak soon.